Justice Alito?
You have competitors in providing internet services. Would you dispute the proposition that your client has a financial incentive not to become known as an internet service provider that is aggressive in terminating service for infringers?
Your Honor, hypothetically, I can imagine that being true, but the facts of this case are 21% of traffic to the other ISPs was infringing. We were 2/3 of that. So the notion that we had a particularly impressive track record of reducing infringement did not deter us from, of reducing infringement, did not deter us from having a program that worked to the point of 98% success.
Is there evidence in the record that you have a financial incentive not to terminate infringers?
We have a financial incentive, like any business does, to keep our customers. But the Fourth Circuit found, and this was a basis for rejecting vicarious liability, that we did not have a financial incentive to increase infringement.
If purpose is the test, would you disagree that there can be circumstances in which a repeated refusal to do anything about infringement by the holder of a single user account could be sufficient to give rise to an inference of purpose? Suppose that we're not talking about a multi-user account, we're talking about an individual user account, and the copyright holder notifies the ISP that this particular account has, over the course of 6 months, has violated the copyright 50 times, and the ISP does nothing in response to that notification. And then after the 50th notice, it begins to send out just a very tepid warning. What you're doing is really not very nice. But 50 more occur over the course of the next 6 months. At some point, and this could go on indefinitely, at some point would there be enough to infer a purpose?
No, Your Honor, because there could be all sorts of reasons why an ISP does not want to cut off a customer. And it's not just a customer who, in your hypothetical, confesses that he's going to continue infringing. I think that another way of answering the question is, think about the flip side. In order to capture that fringe case, we would have to create a world in which ISPs are going after everyone who infringes, including not just that one individual user, of which we have no evidence in this record that we ever knew about that one person, but the regional ISPs and the hospitals and the universities, because that is a world in which at $150,000 per pop, the ISP has a huge financial incentive to cut off the accused infringer at the word go. I will underscore that in that table on page 11, of the 49 infringers who had more than 100 notices, only one was a single unit home. Everything else were the sorts of businesses and multi-unit dwellings that I described.